Hello Year 12s and welcome to this third and final video in our series on workplace relations. There are 4 things that you need to do as you watch this video. First, take the very best Cornell notes that you can. Second, use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you've missed any information and you need to go back over that information. The third thing you need to do is have your vocabulary sheets open in front of you so that you can include in those vocabulary sheets the definitions of key terms, as well as the definitions of any other words that you may be unfamiliar with. And the fourth thing that you need to do is to have your summary books open in front of you. In this video, I will tell you what to write in your summary books. Once you've finished watching this video, please make sure that you read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that information. Our learning intention for this video is that you need to be able to explain the dispute resolution process, including grievance procedures, mediation, conciliation and arbitration. Make sure that you write this learning intention down in your Cornell notes. As you should know by now, workplace relations is about the relationship between employers and employees in the workplace. In particular, this relationship involves, firstly, establishing the wages and conditions of employment of employees, and secondly, settling workplace disputes. In this video, we will focus on that aspect of workplace relations which involves settling workplace disputes. As we have seen in the first video, the aim or purpose of workplace relations is to achieve the best possible working relationship between managers and employees. This is important because positive workplace relations, that is, a good working relationship between managers and employees, increases employee motivation. And, as we know, employees who are motivated will work harder for the business, and this will in turn result in an increase in the productivity, performance, and profitability of the business. In this video, we will be looking at the dispute resolution process that applies to disputes about wages and employment conditions, and the dispute resolution process that applies where an employee is dismissed and believes that that dismissal is unfair. It's very important to distinguish between these 2 kinds of dispute resolution processes, and to carefully read a SAC or exam question to make sure that you know which type of dispute resolution process that question is asking you about. Well, let's start off then by looking at the dispute resolution process that applies to disputes about wages and employment conditions. As a result of watching the 2 previous videos, you should now be familiar with the concepts of collective bargaining and enterprise agreement. Collective bargaining is the process where employees, typically represented by a trade union, negotiate with their employer to agree the wages and conditions of employment that are to apply to those employees in their workplace. This resultant agreement is called an enterprise agreement, also known as a collective agreement. Well, during the process of this collective bargaining, disputes may arise between employees and their employer about the wages and employment conditions that are to be included in the enterprise agreement that they're negotiating. In such a case, the employees are permitted to take industrial action such as strikes. This industrial action, which is taken after an enterprise agreement has terminated and before a new enterprise agreement is entered into, that is, it's industrial action which is taken as part of negotiating a new enterprise agreement, is called protected action. It's called protected action because the employees are lawfully entitled to take this industrial action. On the other hand, employees are generally prohibited from taking industrial action, such as strikes, during the term of an enterprise agreement. If they undertake industrial action during the term of an enterprise agreement, this is called unprotected action. It's called unprotected action because the employees are not lawfully entitled to take this industrial action. And if they do take industrial action during the term of an enterprise agreement, then the Fair Work Commission or the courts may order the employees to return to work and or may require them to pay compensation to their employer for disruption caused by the industrial action that they've taken. There are 6 kinds of industrial action which are available to employees, and these are listed on this slide in order from least disruptive to most disruptive. First, passive resistance, which is where employees refuse to cooperate in completing tasks and take days off. Second, work to rule, which is where employees do the bare minimum required to complete their tasks. Third, boycott, which is where employees refuse to complete a particular task. Fourth, a stop work meeting, which is where employees hold a meeting during work hours to discuss a dispute. Fifth, a picket line, which is where employees blockade their workplace to prevent other employees entering the workplace and to prevent the delivery of goods to or from the workplace. And sixth and finally, a strike, which is where employees refuse to turn up for work. Employers can also take industrial action in response to any of these kinds of industrial action taken by their employees. The form of industrial action which an employer can take is called a lockout. This is where the employer doesn't allow its employees to enter the workplace to perform their work, and during this time the employees are not entitled to be paid. Let's now look at the dispute resolution process that applies where there's a dispute about the wages or employment conditions that are to apply to employees of a particular business. Keep an eye out on the next couple of slides for the instructions that will appear on the screen as to what information you should include in your summary books. Every business should have a dispute resolution procedure. A dispute resolution procedure is a formal procedure that a business has in place to resolve disputes between the business and its employees. Under the dispute resolution procedure, the dispute will be discussed between management on the one hand and the employees or their representatives, such as a trade union, on the other hand. And the purpose of this discussion is to try to resolve the dispute through negotiation. Now, if the dispute can't be resolved between the employees or their representative, the trade union, negotiating with a particular level of management, then it may be necessary to escalate the dispute up through the management hierarchy to a more senior level of management to see whether that senior level of management and the employees or their trade union can negotiate a resolution to the dispute. You already know that every award and enterprise agreement has to include a dispute resolution procedure, and often that dispute resolution procedure will include a procedure that applies to resolve disputes about wages and employment conditions. If the employer and the employees cannot resolve their dispute through negotiation, then the next stage in trying to resolve the dispute is typically mediation. Mediation can occur in one of two ways. First, the employer and the employees may agree to resolve the dispute by referring it to mediation, in which case they will also need to agree the person that is to undertake the mediation. Second, or alternatively, either the employer or the employees may refer the dispute to the Fair Work Commission, and the Fair Work Commission might order that the parties refer their dispute to mediation. In such a case, the mediator might be either agreed by the employer and the employees or appointed by the Fair Work Commission. In a mediation, the mediator facilitates discussions between the parties, that is, between the employees on the one hand and the employer on the other hand. The role of the mediator is to ensure that both sides have an opportunity to explain their side of the dispute. The mediator does not make suggestions about how the dispute can be resolved. It's entirely up to the parties to try to agree a resolution to their dispute. As I've said, the role of the mediator is simply to ensure that each party gets the opportunity to explain to the other party its view of the dispute. And the intention then is that each party will come to better understand the point of view of the other party, and so they might be able to reach an agreement to resolve that dispute. Importantly, the mediator does not decide the dispute. Whether the dispute is resolved and how it's resolved is purely up to the parties, that is, the employer and the employees. Well, if mediation doesn't resolve the dispute, then the Fair Work Commission might then conciliate the dispute. Conciliation has some similarities with mediation, but a major difference between conciliation and mediation is that whereas in a mediation the mediator doesn't make any suggestions about how the dispute can be resolved, in a conciliation, the conciliator, in this case the Fair Work Commission, does make suggestions about how the dispute can be resolved. In fact, a key role of the conciliator is to assist the parties to come to some kind of agreement. So a conciliator is more proactive than a mediator. However, similarly with a mediator, the conciliator does not decide the dispute. Whether the dispute is resolved and how the dispute is resolved is again a matter purely for the parties to the dispute, that is, the employer and the employees. Well, if conciliation doesn't resolve the dispute, then the Fair Work Commission may then arbitrate the dispute. Now, arbitration is a very different kind of procedure from conciliation and mediation. An arbitrator is a bit like a judge. They're not a judge, but they act a little bit like a judge in the sense that they listen to both sides of the dispute and then they decide the dispute. The decision of the arbitrator is legally binding on all of the parties to the dispute. So you can see here a key difference between arbitration on the one hand and mediation and conciliation on the other hand is that in an arbitration, the dispute is resolved by a third party, and the decision resolving that dispute is legally binding on all of the parties to the dispute. This slide sets out the advantages and disadvantages of mediation, conciliation and arbitration as dispute resolution methods. You'll see that down the left-hand side I have listed the different features that we may use as a basis for comparing these three different dispute resolution methods. That should be a pretty clear indication to you that one thing you might be asked in a SAC or an exam is to compare, that is, identify and explain similarities and differences between any two of these dispute resolution methods. Well, let's start off with the similarity. This similarity relates to the person who hears the dispute. In the case of mediation, conciliation and arbitration, the person who hears the dispute is an unbiased and neutral third party, whether that's the mediator, the conciliator or the arbitrator. And this is really important because it means that the parties can have confidence that their dispute will be dealt with fairly. That's because the person who hears the dispute is someone who is impartial and independent. Turning now to who has control over the outcome of the dispute resolution method. In both mediation and conciliation, it is entirely up to the parties themselves to decide whether, and if so how, to resolve the dispute. This is important because it means that both sides, that is, employer and employees, will have to buy in to any agreement that they might make. That is, they both will have an incentive to honour their agreement because they've both had to compromise to reach that agreement in some way. Now, the difference between mediation and conciliation, as we've discussed, is that in the process of reaching that agreement, it's only in the case of a conciliation that the conciliator can make suggestions and assist the parties to reach some sort of agreement. In a mediation, the mediator is hands-off. That is, the role of the mediator is simply to give each side to the dispute a reasonable opportunity to put and explain their case to the other side. Now, arbitration is very different in this regard from mediation and conciliation. In arbitration, it is the third party, that is the arbitrator, not the parties, who decide the resolution of the dispute. And to resolve the dispute, the arbitrator will make an order. That is, the arbitrator will impose their decision or the resolution of the dispute on both parties. It's not an agreement to resolve the dispute that's reached by the parties at all. The resolution is one which is determined and imposed by the arbitrator. Mediations and conciliations tend to be fairly informal. That is, there are no strict rules that govern how the mediation or conciliation is to be conducted. That's largely left up to the mediator or the conciliator. In contrast, in an arbitration, there are certain rules of procedure that apply. They're not as formal as the procedural rules that might apply in a court, but they are similar in the sense that they regulate how the arbitration is to be conducted. Mediation and conciliation are also similar in that because those processes can result in the dispute being resolved by agreement between the parties are free to come up with an agreement that is tailored to their particular circumstances. And that means that because the circumstances of each dispute are different, because each business is in different circumstances, mediation and conciliation are good because they enable all of those circumstances to be taken into account in whatever agreement the parties might reach in resolving their dispute in a mediation or conciliation. On the other hand, in an arbitration, the dispute is resolved through the arbitrator making an order. It's up to the arbitrator what order they might make, but typically that order is not one that can be particularly tailored to the circumstances of the dispute or the circumstances of the business. It's a bit more of a blunt instrument than an agreement arising out of a mediation or conciliation. For both mediation and conciliation, for it to work, that is, for the parties to reach an agreement, both sides must be willing to compromise to some degree. If the parties aren't willing to compromise, they're highly unlikely to reach an agreement in the first place. In contrast, in an arbitration, the parties don't need to compromise because the dispute is resolved not by the parties coming to some sort of agreement, but by the arbitrator making an order. So in fact, arbitration is a very useful dispute resolution method where the parties are not prepared to compromise. For example, where one party is just being uncooperative, or indeed where there is an inequality in bargaining power between the parties, so that one party is in a much stronger bargaining position than the other party, and if they were left to try and reach an agreement by themselves, that agreement would be very one-sided because the stronger party would effectively beat the weaker party into submission. The final point on which we can contrast these different dispute resolution methods is the binding nature of the decision. As we've already seen, in both a mediation and conciliation, the parties reach an agreement, but in fact that agreement is not legally binding on the parties. Either party, either side, might decide after the mediation or conciliation not to honour, that is, not to abide by the agreement. We can contrast that with an arbitration. In an arbitration, the arbitrator's decision is legally binding on the parties. That is, if one party disobeys the order that the arbitrator has made for the resolution of the dispute, then that is a breach of the law, and the other party can take action to have that arbitration decision enforced against the party who has decided to disregard it. This brings us to the second kind of dispute resolution process which we need to look at, which is the dispute resolution process that applies where an employee believes that they have been unfairly dismissed. The dismissal of an employee may result in a workplace dispute where the employee disputes their dismissal by their employer. The information contained on this slide and the next two slides is information that you should already have in the termination management notes that you completed in class. Accordingly, you might want to skip quickly through this slide and the next two slides. Dismissal is the termination of an employee's employment for unsatisfactory performance or indiscipline. An example of indiscipline is where the employee behaves in a dishonest manner. Make sure that you have included this definition of dismissal in your vocabulary sheets. For an employer to dismiss an employee, the employer must follow 3 steps. The first step is that the employer must counsel the employee and follow any applicable disciplinary procedures. At least where an employee is being dismissed for unsatisfactory performance, it's important that the employer has given the employee 1 or more warnings, together with a plan that the employee had to comply with to avoid being dismissed. The purpose of this plan is to enable the employee to take action to rectify their unsatisfactory performance and therefore to avoid dismissal if they can. The second step is that the employer must give the employee written notice which sets out the reasons for the employee's employment being terminated. And the third step is that the employer must give the employee notice of their dismissal. That is, they must be given a period after which their dismissal will take effect. The length of this period depends on how long the employee has been working for the employer. The exception is that where the dismissal is for serious misconduct, then the employer may fire the employee on the spot. That's called summary dismissal, where there is no notice period of dismissal being given. An alternative to giving a notice period is for the employer to pay out the employee their notice period. That means the employer will pay the employee the number of weeks' wages that would otherwise be paid to them during their notice period. Where an employee believes that their dismissal is unfair, the employee may be able to apply to the Fair Work Commission. An employee can apply to the Fair Work Commission where 4 requirements are satisfied. First, the employee must have been employed by the employer for at least 6 months. An exception is where the business is a small business, that is, where the business has fewer than 15 employees. In that case, the employee must have been employed by the employer for at least 12 months. Second, the employee must either be covered by an award or enterprise agreement or earn less than the high income threshold. In the 2018-2019 financial year, the high income threshold was $145,400 per annum. Third, the employee must apply to the Fair Work Commission within 21 days of their dismissal. Fourth and finally, the dismissal of the employee must be harsh, unjust or unreasonable. What is harsh, unjust or unreasonable depends on a number of factors. These factors include, first, whether there was a valid reason for the dismissal, for example, that the employee was underperforming. Second, whether the employee was given a reason for their dismissal and an opportunity to respond to that reason. It may, for instance, be the case that the employee was underperforming because they were unwell or because they were suffering from some kind of personal relationship breakdown. Third, whether the employer unreasonably refused to allow the employee to have a support person present in discussions between the employer and the employee about the employee's dismissal. Fourth, where the dismissal is for unsatisfactory performance, whether the employer had warned the employee about their unsatisfactory performance. And fifth and finally, where the business is a small business, that is, where the business employs fewer than 15 employees, whether the employer has dismissed the employee in accordance with the Small Business Fair Dismissal Code. Where an employee brings an unfair dismissal application to the Fair Work Commission, then the Fair Work Commission follows a 2-step procedure in trying to resolve this dispute between the employee and their employer. The first step is conciliation. In conciliation, the Fair Work Commission tries to assist the employer and the employee to agree a resolution to their dispute. The second step is arbitration. If conciliation does not succeed, then the Fair Work Commission itself decides the dispute by arbitration. This means that the Fair Work Commission decides whether the dismissal of the employee is unfair. In coming to this decision, the Fair Work Commission will need to decide whether the dismissal of the employee was harsh, unjust or unreasonable. And in making that decision, the Fair Work Commission will need to take into account the factors that I've referred to on the previous slide. If, as a result of arbitration, the Fair Work Commission decides that the dismissal of the employee is unfair, then the Fair Work Commission can order the employer to do one or both of two things. First, the Fair Work Commission can order the employer to reinstate the employee, that is, to give the employee their job back. Second, the Fair Work Commission can order the employer to pay compensation to the employee. The amount of this compensation can be up to 26 weeks' pay. However, this amount in turn is capped, and for the 2018-2019 financial year, this amount of compensation is capped at $36,350. Now, think back to our first video in this series on workplace relations. In that video, we said that one of the factors that contributes to positive workplace relations is that the business satisfies, or at least takes into account, the interests that employees have as stakeholders in the business. One of these interests is in having fair procedures for resolving employee complaints. For this reason, it is important that a business has in place effective procedures for resolving disputes between employees and their employer about wages, employment conditions, and employee dismissals. Of course, it's also important to be able to resolve these kinds of disputes effectively to avoid disrupting the operation of the business. Well, this brings us back to a key theme that underlies these videos on workplace relations. Positive workplace relations increase employee motivation. And this is important to a business because motivated employees will work hard, and as a result, they will improve the productivity, performance, and profitability of the business. We've now come to the end of this video. As a result of watching and taking notes on this video, you should now be able to explain the dispute resolution process, including grievance procedures, mediation, conciliation, and arbitration. Please make sure that you read the pages of the textbook referred to on the first slide, and if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that information. Thank you for your attention.